And it wasn't an immediate stroke. The gentleman went to see a chiropractor. His stroke occurred 18 hours after the adjustment. And so he didn't cause the dissection. The chiropractor didn't cause the stroke, but he did miss the diagnosis of dissection, which allowed the stroke to happen.
Why would a law firm be unable to find a chiropractor? And when was this? And has the situation gotten any better today?
Because the lawyer couldn't find anybody who would look at the case. A very high profile case for the profession. And eventually I was retained just because I called him to see how the case was going. And he was like, well, it's not going anywhere. I can't find anyone to look at it.
Hello and welcome to a brand new episode of On the Stand with Ashish Arun. Today's guest, Dr. Stephen Brown, is a doctor of chiropractic and diplomat of the International Academy of Medical Acupuncture, who has built a unique career bridging patient care, university teaching, and expert witness work. Based in Gilbert, Arizona, Dr. Brown has been in private practice since 1997, serves as a faculty associate in the kinesiology department at the Arizona State University, and operates the Chiropractic Experts, specializing in some of the most complex and high-stakes cases in chiropractic medicine. What makes Dr. Brown particularly noteworthy is his deep dive into the relationship between cervical spine manipulation, cervical artery dissection, and stroke, a topic that has generated significant controversy within both the medical and chiropractic communities. His research has challenged long-held assumptions, arguing that many stroke cases following chiropractic manipulation are not caused by the manipulation itself, but rather represents failures to diagnose pre-existing arterial dissections. Dr. Brown has published extensively on this topic in peer-reviewed journals, including Forensic Science International, the Journal of Forensic and Legal Medicine, and Curious. His 2024 research has been recognized as among the top chiropractic studies of the year. He's presented at conferences across the United States and internationally, and serves as a peer reviewer for journals like Stroke and Curious. Perhaps most impressive is Dr. Brown's commitment to evidence-based opinions that serves both plaintiffs and defendants. He's worked on nearly 54 cases involving cervical manipulation and stroke. His approach is straightforward. Follow the case evidence and research wherever it leads. Today we'll explore how Dr. Brown became an expert witness, what attorneys need to understand about chiropractic stroke cases, the current state of research on manipulation and dissection, and how expert witnesses can help attorneys better serve their clients in the pursuit of truth. So with that, let's welcome Dr. Brown to the show. Dr. Brown, welcome to the show.
Thank you.
I want to start by asking you about the recent event where you got fired from the teaching position at Southern California University of Health Sciences. So can you tell us about that?
Yes, I was. I applied for a teaching position at SCUHS, and the gentleman that hired me was very nice, very professional. I submitted an interview. It went to the hiring committee, and I was hired by them. And about a week later, I received a call back, and apparently the powers that be at SCUHS had seen my research, and they decided that my research was not compatible with the vision for their university, and they let me go.
And that reminds me of the many times attorneys would let experts go when the attorney is looking for a specific expert to toe a specific line, and then the expert looks at the medical records, or if it's not a medical case, then whatever the facts and the evidence are presented to the expert, and they offer a counter opinion because that's what the facts tell the expert. So do you see an analogy between the two, and do you feel that attorneys also have this kind of a problem?
Yes, with the opinions that I give and the topic that I'm into, the opinions sometimes don't align with the plaintiff or the defendant in these cases, because the plaintiff wants to state that the chiropractor caused a dissection and a stroke with the manipulation, and the defense wants to say they didn't cause the dissection or the stroke with the manipulation. And most of the time, the truth is somewhere in between. The patient can walk into a chiropractic office with a dissection, and if the dissection is there, then the chiropractor can cause the stroke if the dissection is in place. So sometimes the truth doesn't fit either side's preconceived narrative of the case, so I have to convince plaintiff and defense attorneys to take a better look at it.
Today's episode of On the Stand is brought to you by Xlightum, the AI-powered platform where attorneys find expert witnesses and experts grow their practice. Every week, hundreds of new experts join Xlightum, giving attorneys instant access to qualified witnesses without any finder's fee or markups. Need someone else to handle the vetting? Our concierge service does it all. You only pay when you retain an expert we present. So whether you are searching yourself or letting us do the heavy lifting, Xlitum makes expert discovery fast and smarter. Visit Xlitum, that's exlitem.com, to find your next expert witness today. And you actually started as a law student yourself.
Yes.
So that's interesting because now you work with attorneys a lot.
Yes.
So how did the transition happen? You started as a law student, and going into law is also a very coveted career option for many youngsters. So what happened? How did the law student Stephen Brown ended up being Dr. Stephen Brown and went into chiropractic?
Well, I graduated from Illinois State University with a bachelor's degree in philosophy and history. And when you have that type of degree, you sometimes go to law school. It's about all you can do with that type of degree besides go to graduate school. So I went to law school and I was doing well in law school. I was there for one semester. My best class was contracts and I was really enjoying it. However, I was all working out a lot. I've always tried to be a bigger, stronger guy than I really am. And I was working out at Gold Gym in Pacific Beach in San Diego in 1989. And there's some really well-known professional bodybuilders there. Flex Wheeler was there at the time, and I just couldn't keep up. I injured every body part I had. I could barely walk. My shoulder hurt. My knees hurt. Only person to help me was my chiropractor. So I dropped out of law school and went to St. Louis for Logan College, College of Chiropractic, and I finished there and started practice after that.
Wow. And do you think the early exposure to both law and medicine eventually had some impact or shaped your path to becoming an expert witness?
I think so because I was a philosophy and history major, which are both majors that teach you how to think, how to use logical processes, and so does law school.
Yeah.
And that's what involved in being an expert witness. You have to logically evaluate these cases for the standard of care and come to an opinion. So I think everything set me up for this type of work.
Mhm. And the first plaintiff case came because a law firm couldn't find any chiropractic expert willing to review it. So tell us about that. Why would a law firm be one unable to find a chiropractor? And when was this? And has the situation gotten any better today?
The summer of 2016, I was in practice just like any other chiropractor, seeing patients. And I
Mhm.
got a call from a recruiter at the Expert Witness Institute in New York. It's a company that finds expert witnesses for cases, for all kinds
Mhm.
of cases.
Yeah.
And they have an extensive network. It's a large company, and they have chiropractors on their network. They have resources. They couldn't find anyone to look at this case for the plaintiff. It was a chiropractic stroke case. They called me, and I don't come from a family of doctors and lawyers. I didn't know what she was talking about, expert
Mhm.
witness work. It took her a half an hour to convince me that this wasn't a scam or something. So when she finally convinced me to take a look at the case, I looked at it, and it wasn't an immediate stroke. The gentleman went to see a chiropractor. His stroke occurred 18 hours after the adjustment, and so he didn't cause the dissection. The chiropractor didn't cause the stroke, but he did miss the diagnosis of dissection, which allowed the stroke to happen. And that was my opinion, and the case settled. And I thought that was interesting, so I put my name out there on several ads, and I've been reviewing cases ever since. The end of your question was the most interesting part. Has this changed in 10 years? I don't think so. Lawyers still tell me they have a hard time finding experts to review these cases for the plaintiff.
Yeah.
One of the most famous cases was the case of Katie May, also in 2016, and an expert was not retained on that case for 3.5 years for the plaintiff because the lawyer couldn't find anybody who would look at the case. A very high profile case for the profession. And eventually I was retained just because I called him to see how the case was going. And he was like, well, it's not going anywhere. I can't find anyone to look at it. And I said, I'll look at it. And so I looked at it, and the chiropractor didn't cause the dissection. He didn't cause the stroke. He did miss the dissection, which allowed the stroke to happen. But our profession got blamed for a lot there. We got blamed in the press for years for causing that dissection and causing that stroke. And if somebody would have looked at that case and spoke up, we would have found out, no, we didn't do that. Now, there was a mistake made, but the manipulation didn't cause that dissection or that stroke. So I think it's still hard to find people to review these cases for the plaintiff.
I don't really have a word for it, but like an outsider, somebody who's trying to benefit at the disadvantage of others in the fraternity, because that is something that we keep seeing in the medical associations as well, that doctors are reluctant to review medical malpractice cases, especially if it's within the same state. So why do you think chiropractors are reluctant to look at cases?
I think with the history of the chiropractic profession, it took a long time for us to get, the doctoral degree, for us to get respect from the medical community. We had a lawsuit in 1976 that we won to get the AMA to stop trying to discriminate against us. So chiropractors, I believe, kind of a collective case of PTSD. We always think that the other side is out to wipe us out, to knock us out of existence. Very defensive. So it's not politically correct to take a stand against a chiropractor in a case. But I do plaintiff and defense cases, and I just say whatever my opinion is. I'm not for one side or the other as a witness, which a witness should not be. Witness is just here to comment on the standard of care one way or the other. There's no taking favorites with an expert opinion. There shouldn't be anyway. So any profession, I think you have that stigma with taking a plaintiff case, but I think it's worse with chiropractors because they are very used to being attacked. Our profession was maligned for a long time, and there's that stigma still there. So it's very hard to speak out against a chiro without running into that.
So what made you decide to put your name out there? Because since 2016, you have now done 54 cases. So that's an impressive, it's averaging almost 5 cases a year.
I think because we need to do two things. One is chiropractors have to realize our profession is just like any other healthcare profession. Chiropractors make mistakes, and chiropractors are also accused of making mistakes they didn't make. So we need to have someone to look at the cases objectively. One, just to see what happened, to see if there's a case for the plaintiff or the defendant. That's how this works. We can't just ignore the fact that these cases happen, that these cases are brought. They need to be evaluated because there are times when the plaintiff does have a case, when the plaintiff was injured, and that's not going to stop if we just pretend like this is not happening and no one takes these cases and looks at them. If we look at the cases and write up reports from the cases and analyze them, we can keep this from happening. And the medical profession is very good at that. When a lot of medical professions, you get a case report on everything. Every little thing that happens, there's a case report written by a resident or an intern or a doctor. And that's how the profession improves. Chiropractors need to write more case reports when something goes wrong with treatment so we can prevent it from happening again. So my other motivation is, I guess, just to make the profession safer and more successful by analyzing when things do go wrong and how we can prevent that.
So how did you go about building your practice after that first case? What were a few, like you told me that you advertised in a few places, but other than that, what all have you done from a, like a networking perspective and building your relationship with attorneys you worked with so that new experts especially can learn from your path?
Yeah, I do get calls from people getting into the expert field from time to time, and I wrote an article for Chiropractic Economics about how to get into this type of work if you would like to do that. The things I did was I took out an ad on the Seek Expert Witness website, and I have a free listing with the Expert Institute out of New York. I think I have a listing with Juris Pro, and a few years ago I made a dedicated website for expert work. And other than that, just word of mouth. And again, made easier by what you just asked about. Nobody wants these cases. Nobody wants to look at them. So if you're the one person who's willing to look at them, you're going to get that case. And again, my job is just to go right down the middle and to say what happened with the standard of care, not take a position either way in favor of the plaintiff or the defendant. And I think if you do that, lawyers appreciate the honesty, whether you give them an adverse opinion or an opinion for their case. And I've been busy ever since. So.
Yeah, I mean, wouldn't you say that if you give an adverse opinion to a plaintiff's attorney, that's only saving them money and hours and work and pain down the road because they won't hopefully take a bad case to trial and get a defense verdict and lose all the money they have put into the case?
I think so, and I listened to several of the other podcasts on this series, and these attorneys, good attorneys, I think, don't want yes men. They don't want to be told, yes, there's a case here when there's not. They're going to waste hundreds of thousands of dollars on these cases if there's no case. So I think good attorneys appreciate an adverse opinion, and I give an adverse opinion in almost all my cases because even the plaintiff attorneys that retain me, they all think the chiropractor tore that artery. That's just gospel out there. The chiropractor is dissecting these arteries. And I've only seen that happen once. One time in 54 cases, I think the chiropractor actually dissected the artery. So that's extremely rare. So I give an adverse opinion on almost every case in some ways. And I think good attorneys appreciate that. And they continue to ask me for more opinions. So.
So I believe you also have your regular chiropractic consulting work that you do outside the expert witness work, as opposed to many who would devote most of their time to doing expert witness work. So, what percentage of your time you would say is devoted to expert work where you're reviewing records versus the clinical practice and teaching?
Right now, my clinical practice is about 2/3 of my time, and the expert
Okay.
work is about 1/3 of my time. And the teaching is probably included with the expert witness work there.
Okay. So, for our audience who may not be familiar with this area, can you explain what the traditional belief has been about chiropractic manipulation causing strokes?
The traditional belief is that chiropractic manipulation or neck manipulation done by anyone, a physical therapist, anybody can do this, can tear an artery in the neck, and that torn artery, a dissection, can lead to a stroke. That's their traditional view. So some of that view is correct and some of that view is not correct. There's no evidence that neck manipulation done by a chiropractor or anyone else can tear a normal artery. There has to be a pre-existing issue with that artery for it to tear with the manipulation, and that's very, very rare. I've only seen that once. What happens most of the time is the patient walks in with the dissection. The practitioner, whether it's a chiropractor or a physical therapist or anyone else, misses that diagnosis. And when you adjust over an existing dissection, you can dislodge a blood clot, and the blood clot travels to the brain and can cause a stroke. The big word for that is a thromboembolic stroke. The blood clot is the thrombus, and when it embolizes, we call it an embolus. So a thromboembolic stroke as a result of manipulation is how almost all of these strokes occur. And the good part is they're all completely avoidable if we would just diagnose that dissection and send them to the ER. Of all the cases I've seen, every single one, in my opinion, was avoidable if you just diagnose the dissection and get them to medical emergency.
So, in 2024, you had publications that challenged this traditional view. So, what is the causal relationship? And, like, if manipulation doesn't cause the dissection, then what is actually happening in these cases where patients have strokes immediately after manipulation? That's one. And second, I have a follow up question there. That doesn't this seem to be challenging both medical and chiropractic dogma? And what was the reaction from the community to your research? And was this one of the reasons why the South California University of Health Sciences was spooked by your position?
I can only assume that's probably what part of that was. I didn't ask for any details. The gentleman on the phone was, he's very polite, so we didn't make an extended conversation out of it. But they saw my research and they were unhappy with it, and probably because, as you just mentioned, whether you're on the defense side or the plaintiff side, this research can sometimes upset either side, because the defense wants to say we didn't cause the dissection, we didn't cause that stroke. The plaintiff wants to say you caused both of them, but the reality is the dissection was already there. But if it's an immediate stroke, the manipulation could have caused that by a thromboembolic mechanism, like we just discussed. If that stroke happens the next day, the next week, 3 weeks later, there's no known mechanism how getting adjusted today can cause a stroke 3 weeks later. Now, you may have missed the dissection, which in turn causes a stroke 3 weeks later, but you can't cause a stroke 3 weeks in advance of it. So it depends on the temporality between the manipulation and the stroke.
And is this what you call the intimal flap mechanism in your research, or that's something different?
You're the first person to really ask me about that. I put that in my first paper in 2024. It's nowhere else in the research. No one else has discussed this. I've discussed it with other researchers. However, is there a way that we could adjust a patient with a normal artery and cause an immediate stroke? The only way I can see that happening is if we did cause the dissection can form a flap on the inside of the artery. What if that flap, and the inside of the artery is called the intima, for those who don't know the verbiage on this. If there's an intimal flap, what if that flap itself obstructed the artery without a clot, without a thrombus, just the flap itself could obstruct that artery? Is that possible? And I don't think anyone knows because there's no research on just an idea that I heard from Dr. Peter Tushin, who is a researcher in Australia. It's a great idea. I can find no research on it, but I did find, which is interesting, the aorta and the cervical arteries are bigger than the vertebral artery. So we can get some pictures of them. I saw a video. I can't find it again. There was an intimal flap in the aorta. They got a picture of it when it just happened. There's no clotting yet. And did the flap obstruct the aorta? It did not. It just flapped. It just flapped back and forth. So there was no obstruction. It was, I'm sure impeding blood flow, but it wasn't obstructing blood flow completely. So I think that in the vertebral artery, it might be the same thing. The flap would form and it would just flap, but it would not really obstruct the artery until clots formed. And I'd like to see more research on that, but I haven't found it out there yet.
Mhm. So, how do you explain the fact that strokes can occur seconds after manipulation if dissection takes time to form a clot?
Yeah, and
Like what
that's the
happens?
issue there. If the stroke does occur seconds after manipulation, the clot
Yeah.
must have already been there. So that's about the only way you could have an immediate stroke. So when we have these strokes that occur right there on the table after an adjustment, the
Hmm.
defense is very hard pressed to find an alternative explanation for that. What else could have caused that? So in a defense case, the alternative explanation, the most common explanation that is given, is it's sheer coincidence. This person just happened to get adjusted, just happened to have a stroke at the same time. And juries have a hard time buying that, I believe.
Yeah.
That's not intuitive. But on the other hand, I was in a jury trial this past summer, and apparently the jury did buy it. So there was a defense verdict for the defense on all counts. It's an interesting idea, but I think it's very, very unlikely people are just happening to have strokes at the exact moment they get adjusted with no causal relationship.
Hmm. So, can we assume that there would possibly be pre-existing condition that was not diagnosed? The patient didn't know about it. If they were earlier medical providers, they had not recorded it. So, what are chiropractors missing here? I mean, if this is what is happening, and what should they be looking for that would indicate that this is already present and there may be the chance of an immediate clot?
Yes, so what chiropractors are missing is that for this to happen, for someone to have an immediate stroke, the
Mm-hmm.
research shows there must be a dissection there beforehand. And the
Yeah.
most common symptoms of a dissection are neck pain and headache, distinctive neck pain and headache. It does
Okay.
take a process of diagnosis to distinguish this neck pain and headache from everyday neck pain and headache, but it can be done with the proper diagnostic protocol. 2019 study by Dr. Chaibi out of Norway detailed this 6 years ago. It's been in literature for 6 years. Very few people in chiropractic have read this study. There's also studies by a physical therapist. The 2020 Rushton study has been around since 2014, actually, with a chiropractic co-author. So these diagnostic algorithms to detect neck pain and headache from a dissection are out there, and they do work. If these algorithms had been applied in my cases, none of those strokes would have happened. We just have to make this known to the profession that this is what we think is happening. This is how we can prevent it. The research is there. So none of these strokes have to happen. So we have to detect that dissection before the adjustment. We have to exclude it before we adjust someone.
So, when you evaluate a case, what are some of the key things that you look at to determine if the standard of care was met or not?
The first thing I start with is the records, obviously.
Hmm.
And the main areas we look at in chiropractic, I assume they're like any other medical malpractice case. Informed consent
Yeah.
is one thing to look at. I always give a causation opinion on the dissection and the stroke when I review a case. Some chiropractic standard of care witnesses don't give a causation opinion. They leave it to the neurologist. But it's very difficult to evaluate standard of care if you don't at least have an opinion on causation. So I give a causation opinion, and the main opinion in these cases is the diagnostic decision. Was there a failure to diagnose a dissection
Yeah.
that walked into the office? That's the main thing we look at in these cases.
So, what would a proper informed consent look like, especially for cervical manipulation?
Yeah, this is a great question. I released my first study in 2024 on this topic, and basically no one cared. I presented at a few national conferences and had a few comments on it, but there was no reaction from the chiropractic research community to this. They really, I think they just wanted to ignore it if they saw it at all. However, a year later, earlier this year, I published a study with Dr. James Lehman of the University of Bridgeport Chiropractic Program on informed consent.
Hmm.
Now, when you start talking informed consent, people pay attention. This study pissed a lot of people off. There was a rebuttal to our study just published in the Journal of Contemporary Chiropractic by Jeffrey Wilder, James Demetrius, and we are in the process of rebutting their rebuttal, which will be out on the 30th of this month, published in the European Society of Medicine Journal. So when you start talking informed consent in chiropractic, people perk up their ears and pay attention. No one wants to talk about causation, but they want to talk about informed consent. And the answer is, well, if it is possible to tear an artery with an adjustment, now that's not likely. You'd have to walk into the office with Ehlers-Danlos syndrome, a connective tissue disorder like fibromuscular dysplasia, Marfan syndrome. You'd have something really wrong with your connective tissue for that to happen. So there should be some consent for that, because even with a detailed history, it is possible to miss that. It's possible a chiropractor could miss that. It's possible it hasn't been diagnosed yet. The patient doesn't know they have that. That's very possible. I've only seen it happen once, and that was avoidable. But the most common thing, the most common pre-existing condition that can make the arteries prone to dissection, again, this is my experience from my research and my cases, is migraines. There's something to do with the genetics of migraines. That genetics also causes problems with the arterial wall. It makes it weaker. Dissections are very common in people with a history of migraines, with or without aura. So in my opinion, the longer I do this, I think that a history of migraine should almost or should be a contraindication to getting your neck adjusted, because those vessels are sometimes not very healthy at all. So the main thing to inform consent for the dissection would be you may have one of these conditions that we're not aware of, and it could cause a dissection, but that would hardly ever happen. The second thing to consent to is you may have an existing dissection that we could dislodge a clot from and cause a stroke. That does happen, and that needs to be in there, worded that way. Yeah. And some chiropractors don't want to word it that way. They don't want to say this out loud. I say it to all my patients. This could happen, this could happen. And they say, do you think it's going to happen? I say, no. Based on the examination and history, I don't think you have a dissection in your neck. There's no evidence of that. And then they get adjusted. But they have the right to know what could happen, and that has to happen. And that's where you get the controversy in chiropractic. People do not want to have to talk about that with their patient.
Again, like most of your opinions have been adverse to plaintiff attorneys when they bring you cases. So you must have seen them making a few mistakes or taking a wrong approach, which is why they took a case and after the initial screening brought it to you for your review. So can you tell us a little bit about some of the classic mistakes or common mistakes that you keep seeing attorneys making on these cases?
The big mistake I see, and probably experts from medicine would say the same thing, is the attorney accepts a case and goes ahead and works up the case and does the filing, the legal filings, and never retains any experts. They decide what they think happened, and they write everything up, and then we can't get the other side to settle. Then they decide to retain an expert, and they've already put $100,000 of time and effort into this thing. If they would have hired me or someone like me first, and I just give an opinion and get deposed, most of these cases settle 2 weeks after I get deposed. So that would save them a lot of time and money. So I'm not an attorney, but if I had to give attorneys advice, I would say the first thing you should do, especially on a chiropractic stroke case, is retain your expert and get an opinion. If there's no opinion for the plaintiff, then don't bother anymore. If there is an opinion, make it the right one. Don't accuse them of tearing the artery when they didn't. And don't accuse them of causing the stroke if they didn't. So I think getting the expert first is the key for all these cases, but especially the chiropractic stroke cases.
Okay. And I also wanted to ask you about the custody studies. We saw that several defense attorneys cite the 2008 and 17 studies, which show no increased risk. And then you also had a recent commentary which suggested that there are issues with how these studies themselves have been interpreted. So can you tell us a little bit about what these studies are? What is their impact in chiropractic litigation? And why do you think that there is an issue with how these studies have been interpreted?
These two studies, the 2008 Cassidy study and the 2017 study, especially the 2008 study, are probably the two most well-known famous studies in the history of chiropractic research, especially the 2008 study that dealt with vertebral artery dissection, because that's more common. And this study is very often misinterpreted. Just in the introduction, you said defense attorneys quote these studies to say there is no increased risk. Stop, and then they go on with their sentence. No increased risk of what? They have to keep going with that, because the study does not say there's no increased risk of stroke with an adjustment. It says it's just the same as a medical doctor. In other words, if you go to a medical doctor or a chiropractor based on this study, you are equally likely to have a stroke within 30 days of that appointment, which is concerning, right? That makes me not want to go to a chiropractor or a medical doctor. I don't want to go to the doctor and have a stroke within 30 days. So the question is, what are they not seeing in the study, or rather, what are they refusing to see, or what are they refusing to bring out of the study? And I'm not the only person to criticize this study. Other medical researchers have too. Epidemiological people have problems with some of the epidemiology, which I'm not an expert in. But the problem with that reasoning that we just talked about is the risk of stroke is the same with DCs and MDs in the 30 days after the visit, but they did not study the first day after the visit. And if a stroke is going to happen after adjustment, it's going to happen in the first day. It's going to happen in the first 60 seconds usually. And they didn't study that. They studied days 2 to day 30. And you have to study day 1. Day 1 was not studied. The first hour after the adjustment was not studied. The first minute after the adjustment has to be studied. That's when these strokes happen. So they are misquoting the study, they're misusing the study, and I pointed that out several times, and it's starting to get some traction. People are paying attention. Like I said, we finally had a researcher, Dr. Wilder and Demetrius, actually rebutted one of my studies this year in peer review. So at least we've got their attention. At least they're fighting back now. They're wrong, and they will be proven wrong. But that's the issue. These Cassidy studies did not evaluate the immediate exposure period, and that's when these strokes happen.
Dr. Brown, you also shared a video of a case where a young man went for an adjustment, and immediately after the adjustment, he felt that he is unable to walk, he cannot drive himself back home, and then he had to actually call a friend to take him home. The chiropractor told him to go back, ice it, and that he would start feeling better in a few hours. But those feeling better in a few hours never came. And so, can you tell us a little bit about this case, and what are some of the key takeaways that probably attorneys, chiropractors, and the general public should take from this case?
Yeah, so that's a case that has settled now, and I can't violate the terms of the settlement. But the video that I sent you is public. It was a plaintiff video, meaning the plaintiff side made this video. They call it a settlement video. We're going to show this video to the defense. This shows our case, so they will just give up and settle this case. It's a 20-minute video. It's very good. You've seen the video professionally done, very compelling when you watch it, and it makes the case for the plaintiff. And I can discuss the video because the video is, it's public property.
Yeah,
It's
we'll
out
link
there.
to it. Yeah.
So what this video shows is what we've been discussing is, one, this gentleman walked into the chiropractic office with a dissection. The chiropractor missed the diagnosis of dissection, and this was an immediate stroke. He did have immediate symptoms right with the adjustment. And here's the second thing. The chiropractor missed the diagnosis of dissection. He also missed the diagnosis of stroke. And this is what is concerning in these cases, because I have 34 cases of immediate stroke. So I have 54 cases. 20 of them was a non-immediate stroke. 34 were immediate. Unfortunately, in the majority of those cases, the chiropractor failed to diagnose the dissection that walked in the office and failed to recognize the stroke that happened right on the chiropractic table afterwards. Chiropractors just seem to have not a good awareness of what a acute stroke looks like. That's what acute stroke looks like. Nausea, vomiting, dizziness, ataxia, that's an acute stroke. And I think in the general public, we have that acronym, the FAST acronym. There's these 4 letters. For a stroke, you have facial asymmetry, these 4 things you look for, and then you call 911. But those aren't the things that happen with an acute stroke. You don't always have a weak arm with an acute stroke. You don't have like a drooping eye or drooping mouth or difficulty talking. The most common symptoms of an acute stroke are dizziness, nausea, and vomiting, and vertigo, and ataxia, and sweating, and chills. I just had a case the other day like this. And chiropractors are not really trained to see that that is a stroke. They just think the patient, maybe they're sick for some reason. There's all kinds of things they think are going on. And that's what we're trying to educate the chiropractic profession about, is that is not a normal reaction to an adjustment. That is a stroke most likely caused by dissection. And when in doubt, the obvious course of treatment is to call 911, even if you don't know what the heck it is. 911 is what you do. So we're trying to get that message out there.
So I did look at the video, and I could totally understand why there was a settlement after watching this video. So thank you for
But
sharing
very
that.
interesting, there was not a settlement after the video.
Okay. So
This is a very interesting case. They set up this case, like I was discussing before, without a chiropractic expert. They made that video before they had a chiropractic expert, and they sent the video to the defense, and the defense said, no, we're not going to settle, even after seeing that video. So they retained me. I gave my opinion, I got deposed, and then they settled. So again, they probably could have made that case a lot shorter if they'd retained me first. I don't know, but that's
Mhm.
another case where no, even the video itself was not enough to settle that case. You have to have an expert to convince the other side that this is not going to go well for them in a court of law. And I always want to make a disclaimer there. Why didn't I post the defense video? Because you want to give both sides, right? I showed the plaintiff video. Where's the defense video? They didn't make one. If there was one, I would have posted that too, with their permission, of course. The plaintiff gave permission for that video to be shared. And it is a plaintiff video. It is biased for the plaintiff. That was the purpose of it. But there was
Yeah.
no defense video made.
Mhm. So you describe your approach as put aside dogmatic beliefs and follow the case evidence and research wherever it leads. But how do you maintain that objectivity, especially in this field where there's so much controversy and where you're still trying to debunk a lot of basic beliefs that have been ingrained for years in chiropractors? When chiropractors are, like you said, most of them don't have that eye to recognize that somebody is having a stroke on their table. So when the field is like that and there's so much controversy, how do you maintain that objectivity in your
It's difficult
review?
sometimes. I think any medical expert will tell you that it's never enheartening to see one of your colleagues make a mistake that caused a patient to have a problem. You just have to stay focused on, and I've been discussing this with some people, the purpose of the expert witness, and some of your other guests made the same comment. We are not here to defend the defendant or the plaintiff. We are here to defend the standard of care. Our only goal is, what is the standard of care? Was it followed? That's our only concern. Now, as a person, of course, I'm concerned about the defendant or the plaintiff. As an expert, my only concern is the standard of care, and we'd have to stay focused on that.
Mhm.
And the standard of care is patient-centered. The standard of care for all medical professions, chiropractic and otherwise, should be patient-centered. So if someone, well, your opinion favored the plaintiff, well, maybe it favored the patient, because the standard of care should favor the patient. It should be a patient-centered standard of care. So that's a distinction that has to be made too.
Yeah. And you can meet the standard of care and there can still be a bad outcome. So there's
That
no
is
way
true.
to.
I was listening to some other of your guests talk about this. I had a case like that, several cases like that. There are times when the chiropractor can cause an immediate stroke, but there was no breach in the standard of care.
Yeah.
Mostly because in these cases, for the chiropractor to make that diagnosis, it's a subjective diagnosis. It's made from subjective information and history information. If the patient fails to give the proper history and subjective information to tell the chiropractor what happened, he can't make that decision. If you don't tell the chiropractor you have god awful neck pain and headache for 22 days and you just fell down and hit your head and you had a car accident, he can't make that determination. So the patient has to be truthful and honest in their intake paperwork for the chiropractor to make that decision.
So let's talk a little bit about credentials now. And because you've pursued extensive postgraduate education and you have a busy practice, you're doing a lot of expert witness work, but you're also working towards the diplomate of the International Academy of Neuromusculoskeletal Medicine. And that my basic research tells me is 300 hours of coursework. So, what's the motivation to invest so heavily in continuing education? Like, is it for expert witness work, or is it for like being a better expert, or is it for your general consulting practice that you have?
Well, I think everybody, well, all physicians want to be better doctors, whether they're chiropractors or medical doctors. But specifically, that's what makes you the expert. If you're the guy that's taken the seminars, you're the guy who's gone to the classes, you're the guy who has gone to these webinars and sat there and read the research and reviewed it, that's what makes you the expert. And I've taken every postgraduate course on manipulation and stroke I know of, every single one. There's like
Yeah.
30, 40 of them out there. And this the larger course with 300 hours just makes you a better doctor and a better expert. So, and the majority of chiropractors have not taken any of these courses. When we depose the defendants in these cases, well, tell us what kind of postgrad work you have on the topic of cervical artery dissection, manipulation, and stroke. The usual answer is none. And so we need to get this information out there, and that's how you do it. And I wrote an article recently. I think to some degree, all chiropractors should be experts in this. You've got
Hmm.
this with chiropractic. There's very few things a chiropractor can do to harm you because it's a very, very safe type of treatment. You've probably heard that our malpractice premiums are very, very low. They are. Mine's like $1,600 a year. And some medical doctors pay 6 figures a year,
Yeah.
because manipulation, as a general rule, is very, very safe. However, it's not perfectly safe. Nothing is perfectly safe. If somebody walks in with a pre-existing condition, that could make it unsafe. So we have to get that message out there and realize that although manipulation is safe, nothing is perfectly safe. I've actually heard defense expert witnesses under oath, in deposition and in trial, state that there are no possible serious adverse effects from a neck adjustment. It's not possible to harm anyone. And that's just not true. That's only true if they don't walk in with anything else wrong with them that could contraindicate the adjustment. If they walk in with a weak artery disorder, with a dissection, with weak bones, with a disc bulge, with a spinal epidural hematoma, you could harm them by adjusting them. And that's an idea we have to get out there in the research, and we have to get chiropractors to take these postgraduate classes and see that.
Mhm. So, can you share a couple of courses for somebody who's not taken any? What would be the first few which you would categorize as essential courses that they should take?
I put an article on LinkedIn recently with that.
Mhm.
I think the best one is probably, there's a seminar sponsored by the American Chiropractic Association, taught by Dr. William Loretti. Dr. Loretti is an expert witness and also a very good witness who will give an opinion for the plaintiff or the defense. He will go wherever the standard of care takes him. And his course is very, very good. He actually acknowledges in his course, sponsored by the American Chiropractic Association, the thromboembolic mechanism. He acknowledges that's a thing. So that course is worth taking. Other good courses by another doctor, chiroclasses.com, Joseph Ferezzi. Very good courses. He acknowledges the mechanism. I think those are the two best. There's a gentleman named Dr. James Demetrius. He's a critic of my work. However, his company is Postgrad DC, and he has the only certification in cervical artery dissection diagnosis offered by our profession. He is very concerned with diagnosing that. Now, he won't acknowledge that you could cause a stroke by adjusting over it, but at least he is concerned with getting it diagnosed. So I can recommend his course, even though he doesn't agree with me on everything. He is very concerned about getting that dissection diagnosed so we don't adjust it. So props to him for that.
And you've been deposed and you have testified at trial both. Is there a difference? And if there is, like, what is it about the experience that's different? And tell us if you have any memorable cross examinations that you can share without revealing any confidential
Right.
information.
I think trial is actually easier because by the time you get to trial, you've been deposed, you've already stated your opinion in writing, you've been quizzed on it once by the attorney, you know what he's going to ask. So the trial is more of an ordeal to go there and so forth, but the trial is the easy part, I think. The deposition is where you really have to get your opinions fleshed out. And even then, before the deposition, you've already written your report. The depositions and trials, to me, are probably the easiest part of this. As far as memorable examinations, I've only been to trial 3 times. Most of these cases, I've reviewed 80 cases, only 3 of them gone to trial. Most of these cases just settle with chiropractic, as with most fields. Most medical cases settle. I think only like maybe 10% at most go to trial. One of 3% maybe. But the most recent case, I was cross-examined for 4.5 hours just this past summer. So, and again, it wasn't difficult. He's asking me 4.5 hours of questions I had already answered in the deposition. He was just reviewing my report, but it was a 4.5 hour cross examination, and that was a tough one just to sit up there and take those questions over and over.
Mhm. So, I think it was Alvin Wolf who I was interviewing, but I may be wrong. So it's one of the podcasts, this trial attorney, and he said that at times I would not depose the opposing expert because if I depose them, then they get another chance to prepare for the trial testimony, and I would cross-examine them directly at trial. So, what's your opinion on that strategy? Do you think attorneys should consider doing that, or it's always better to depose and then go to trial?
I did watch the episode with Dr. Wolf. That was very good, as
Hmm.
most of your episodes are. I think that's up to the attorney. As an expert, I mean, I know my opinion. It's not like if you're going to give it to you in trial or deposition, you're going to get the same opinion. Um, if I was an attorney, I would just say the more preparation, the better. If I've deposed this person once, maybe in the deposition, I could get something out of them that I could use against them in trial. I mean, I'm the kind of person who believes in being more prepared than less prepared, but
Hmm.
Mr. Wolf is a professional attorney. He's won a lot of cases, so he can make his own decisions on that. But his episode was very good. So.
Hmm. Oh yeah, he's brilliant. I think he started a new podcast with another senior attorney where they talk about different cases. So that's been doing pretty well. And even though he hasn't told me this, but I think I got the podcast sparks ignited in him when he came to our podcast. Anyhow, so shout out to Alvin Wolf there. Dr. Bond, you've also written about 10 ways for DCs to survive a stroke malpractice claim. So again, from the attorney's perspective, what are the red flags that indicate a strong case?
Yeah, that was an article I wrote because everyone's giving me a hard time for not doing defense cases. I'm like, well, I never get
Hmm.
offered a defense case. Every case
Yeah.
I've been offered, I've taken. I do have defense cases. I've never refused one. So I thought that article would be nice to get out there. That I'm concerned with defending DCs too. You know, that has to happen. The standard of care is always our main concern. But the best way to defend a DC in this case is to never have this case. For the chiropractors to practice defensively so these cases never happen. Um, uh, what is the number one thing chiropractors could do to avoid these cases? Be a better doctor. Be a better diagnostician. Chiropractors worked a long time to get that doctor after their name. And they have now that we have it, you have to keep it and earn it. And that means when someone walks in your office, you can't assume they need to be adjusted just because their neck is out. There's a million things that could be. That could be a spinal epidural hematoma. That could be an infection in the spinal cord. That could be a vertebral artery dissection, a carotid artery dissection. That could be all kinds of things. And you have to make sure that's what it is before you adjust them. If chiropractors would just exclude these things before they adjust, these cases wouldn't happen,
Hmm.
in my
And
opinion.
so, what documentation is most critical in these cases? Because again, you would begin your review with the medical records and you would look at a lot of documentation. And then there are these different schools where now many people are saying that there is over documentation happening. In at least in some medical fields, I'm not very sure about what chiropractors do. So again, like I'll lean on you to clarify that for the audience. But what documentation is most critical in chiropractic malpractice cases, like medical records, imaging, consent forms? What do you really need to see, and how often do you find that poor documentation is probably a deciding factor in the case? What does that tell you?
For the documentation for chiropractors, we use the same type of software that medical doctors use.
Hmm.
Does that software force us to do over documentation to keep insurance companies happy? I would probably agree with that. I mean, I believe in taking a good, thorough chart note with the history and examination, but some of the stuff they put us through, clicking boxes all day long, is just insane. But that's the situation we're in. So,
Hmm.
but I also believe that more documentation is better than not enough documentation. So you have that too. As far as what records are important for a chiropractic expert, sometimes they only send me one or two things, but I would say to qualify that, the main thing I need is the records before the stroke occurs. We want to see if they walked in there with the dissection. Now, once the stroke occurs, I review the ER records for the first 72 hours. But as far as long-term damages, no, that's not my job. I'm not a damages expert, so I don't know what happened 2 years later. I do give a causation opinion based upon what happened that day. But all the records I need, all the records up to and including the ER records are very important because we have to find out what did the patient walk into the office with? Did the chiropractor ask the right questions? And did the patient truthfully and honestly answer those questions? Because the chiropractor can't make the right decision. No doctor can make the right diagnosis without the proper history. And I think this is common with chiropractors because many people, for better or worse, still don't think of chiropractors as doctors. I'm just here to get my neck cracked. Do I really have to fill out this 30-page history form? We get this all the time. I'm just here for an adjustment. Do I have to fill this out? Yes, you do. And sometimes they don't. We've had people walk out because they wouldn't fill it out. I'm like, well, then you can walk out. That's what's going to happen there. But we have to have that information, and patients have to realize it's a two-way street. We need this information to properly treat you. If you just refuse to write down you've had these surgeries, these problems, these conditions, that's a problem, and that would actually help defend the chiropractor if it went to court because he can't make decisions based upon faulty or missing history information. So that would be the records needed for a chiropractic expert, which is like every other expert. And even the imaging. I've reviewed imaging for these cases where the radiologist missed a dissection or missed a disc herniation. I found one just the other day. I found an extrusion that had gone out and migrated down the vertebral body. I called the radiologist and I was like, I'm just an amateur, but I think I see a disc coming out and extruding here. Do you see that? Oh, yeah, I see it. Audit to the report. Thanks. So, I mean, radiologists miss things too. So you've got to look at the imaging, you've got to look at everything and see what's going on. Poor documentation is just more evidence that this was not a very thorough doctor. And when you say that in front of another attorney, they're going to say the same thing. Dr. Brown, do you think the poor documentation caused this patient stroke? No, the poor documentation did not cause the stroke. However, it's not looking good for your guy when he doesn't write anything down. And just like with medical notes, we have that function where you can just copy over the last note. And I just saw an article this morning about that. Medical doctors were getting in trouble for copy and pasting their notes from the last one. And the same thing in our software. Some chiropractors do just take manual notes, which they shouldn't because they don't do a good job. But copy and pasting the medical software notes is probably just as bad.
Yeah.
If you copy and paste that note to get started, that's fine, but you have to customize that note so it reflects what happened today. And sometimes that's not done. So poor documentation never caused a stroke. No. But they ask me that all the time. But poor documentation is evidence. This is not a very good example of doctoring on the part of the defendant.
Mm-hmm. And another thing that I keep seeing, like these EMR audit trail experts and people who review records in other disciplines keep talking about, is that they've seen instances where after a bad outcome, the doctor has gone back and made changes to their notes. So then, one, there is poor documentation or wrong documentation. And secondly, they try and do some cover up. Even though it's not their mistake, they don't really need to do that. So, do you have an advice to chiropractic doctors who tend to do this or maybe thinking about doing this the next time there's a bad outcome?
Yeah, I have all kinds of advice on that topic for attorneys as well.
Mm-hmm.
The audit report you mentioned, I think should be done in every single case. As soon as you get the notes, as soon as you contact me, the second thing you do is get that audit report and see what happened. And chiropractors and medical doctors have to be aware, for your software to be approved by Medicare, it has to have an audit report function. They can go in there and see every single keystroke you made in there. And if you did that the day you got the subpoena, and this happened in a case out of Chicago, my second case I ever had, we got the records and we got the audit trail. The day this guy got his subpoena, found out there was a case, he went into his software and altered the note like 172 times. So there's no telling what happened with that note. And apparently he just didn't know that audit trail was a thing. So obviously they deposed me, and actually that one, I was scheduled to be deposed. They settled the week before I was deposed on that one, after I pointed out the audit trail. So I think the audit trail is something that attorneys and experts and plaintiffs and defendants all have to be aware of. Those audit reports, a lot of it is done by nursing experts I've seen on LinkedIn. I think that I can't remember the name of one lady I was looking at. Audit reports should be a part of every single case, in my opinion.
Yeah. I think it's, I can't remember the name as well, but there are a couple of audit report experts who do training, who also teach nurses how to do audit trail reports. So yeah, I think I completely agree with you on that. So what's the future of expert testimony in chiropractic malpractice? And especially with close to a decade of experience, we are almost in 2026 now. How do you see the role of expert witness evolving in chiropractic cases?
I would like to be positive and say there'll be less of a need for it, because with the injuries we see with chiropractic care, they almost all occur because the plaintiff or the patient walked into the office with a pre-existing condition. That condition was not diagnosed, and when you adjust over a condition, you can cause a problem. If chiropractors would just diagnose these conditions and not do the adjustments, maybe we wouldn't have these cases, or at least have less cases. So I think that as the profession realizes that these are not injuries being caused by the adjustment in and of itself. Adjustments in and of themselves are safe if they're not done over a pre-existing condition. If the chiropractic profession can get better at diagnosing these conditions, there'll be less cases. I want to say no cases, but things are going to happen. At least less cases. So I would hope that the future of expert witness work in chiropractic is less cases would be a great thing. So.
I don't know how attorneys would feel about that. but I'm pretty sure the chiropractors and the patients are going to be very happy if that happens. Which brings me to the most burning question of 2025. How is artificial intelligence making an impact on your practice as a chiropractor and as an expert witness?
Everybody's talking about this. I did a seminar in Chicago, the American College of Chiropractic Consultants, and we had a roundtable discussion. And one of the topics was stroke. The other topic was AI and how it's affecting our practices. And I see it every single time I log onto LinkedIn. There's an AI post or so forth. Do we use AI in my clinical practice? No, we just treat patients. Do I use an expert witness practice? Yes. Do I let it write my reports? No. I think it's helpful to do some research on certain things. The main thing I do is when I use AI more for research than for reports. I have 14 peer-reviewed studies, and especially when I started, I didn't know anyone in chiropractic research. I was just a practitioner. I didn't know the people I know now. I didn't have anyone to run my studies by. Is this any good? Could you look at this for me? What I do now is I make the entire study up and I load it into AI. I like to use Grok AI by X. Load it in there and load in all your references. It will give you a peer review. Say, please peer review this study for me for the Journal of Chiropractic Medicine. It will give you a great peer review. It will knock out 90% of the problems with your study, and then you can submit it to the Journal of Chiropractic Medicine, and there's less chance they're going to kick it back to you. So I use it mostly to peer review my research, I think is the main function of it. It doesn't do well with reports. I think it knows too much. It thinks too much. It goes places it shouldn't go. So I may use it to help with the report, but I don't think we're to the point where it can write a report yet. And I think I saw something the other day. Elon Musk was talking about this. There's a lot of companies out there, and you may have seen these with the type of work you do. They have this. Are you tired of reviewing 10,000 pages of medical records? Well, buy our AI software, put the records in the software, it'll read them all for you. And I've tried all of those. They don't work very well because the AI is not good enough yet. But Elon Musk AI is already that good. So we don't need these other software programs. If you want to use AI, we already have the big fancy programs, the Grok AI, the Chat GPT. Just use those. They're much easier. I think they work better. So I do use it, but I don't use it to write my reports. Is the key. Everyone asks that. No, it's not writing my reports. So.
Yeah. No, in fact, the previous expert I interviewed in this series, he's a chemical engineering expert who works on EV batteries. And he also, again, like I asked him the same question. And in fact, he extensively uses AI in his practice. But again, for the same things, like for strategy, to attack the problem from different angles, and then without uploading any case data into the AI, but telling the AI about, okay, this is the kind of dilemma I have, this is the kind of analysis I'm looking to do. Give me approaches to do that, or how can I do my work faster? So I think, so that was an interesting conversation about how experts can benefit from AI, and I agree with your take on AI as well, where the foundation models is what we call them, the chat GPTs and the grogs and the Claude, and they have actually become much better at doing the specialized workflows that these special softwares were doing. So initially, a couple of years ago, when these models had just come out, people, like, maybe fine tuning was helping, and these custom models were doing a much better job than the base models. But now the base models, again, like, I completely agree with you, they have all become really good. So a lot of use cases can be done without having to subscribe to a specialized software. I think the main moat is the data, like what kind of data your model has. Again, like it's all a use case, like it differs from one use case to another. But
I can give one example. I was doing some research and I fed my paper and my sources into AI and asked for its feedback, and it came back with a conclusion I hadn't reached. It actually should be considered a co-author because it said, "What about this, this, and this?" I'm like, "Oh, you're right." So yeah, he actually changed the research because it found something I didn't see. So it was very interesting.
so is it, so Dr. Brown, this was, like a really interesting conversation about the work that you do, about issues involving chiropractic medicine and malpractice and litigation. In fact, like, I mean, it's really eye-opening that something as simple as getting your neck cracked can have these kinds of repercussions. And what was really eye-opening was the fact that many chiropractors don't know how to spot that a person is having a stroke. So
And the reason I
this
started
is,
the video is because that's very hard to believe. It's
yeah.
very hard to believe somebody could be having this event in front of you and you don't recognize it. And I don't think it's the chiropractic education that's the problem. Or education, if you look at the numbers, is the same as the medical doctors, the amount of classes, this, that, and the other thing. The main thing is the clinical experience. We don't have as much clinical experience as an MD. We don't have the residency. No chiropractor has done a 1-semester rotation in a stroke unit. If you've done that, I'm pretty sure you're not going to miss a stroke. Once you've been in a stroke unit for 4 months, you've seen these things, you know what they look like. Chiropractors, we don't have that, and I think we need to have that.
And so do you think continuing education can play a role there, where more courses can be created around, like spotting strokes? And are there any courses already that maybe chiropractors are not taking, or it's not a part of continuing education right now?
That's what people in chiropractic are trying to do. At the University of Bridgeport, my colleague Dr. James Lehman, he has these residencies available for chiropractors. It's through they call them federally qualified healthcare centers where chiropractors can
Okay.
go work in these and get real world experience seeing people with actual medical problems, the type of problems you would not want to adjust somebody if they had those things. And you won't see those if you don't go to that type of area. And this 300-hour program that I'm in, that's similar to what medical doctors have their residency, their 3-year residency. We don't have that. This helps to make up for that. 300 hours of work and things that you probably didn't get in school, experiences you wouldn't have had otherwise, to make you a better doctor. So there are people in chiropractic, notably University of Bridgeport is one of them, trying to get these experiences to chiropractors. So we have experience with these things. So we know what a stroke looks like, what an acute stroke looks like anyway. So that is being done. Does more need to be done? Yes. But is that being done? Yes. People are trying to make that happen.
Thank you, Dr. Brown. Thank you so much for sharing your expertise and insights today. For attorneys or anyone else who wants to learn more about your work or discuss a case, what's the best way to reach you?
I have my expert website, chiropracticexperts.com. My email is drbrown@brownchiro.com, or you can call me 602-538-2698. Text or call anytime.
So we'll link to your website and your LinkedIn, and we'll also add the email and the phone number in the show notes, so anybody listening can look them up and get in touch with you. Thank you once again, Dr. Brown, for your time today. I learned a lot, like I always do on these interviews. That's probably my favorite thing about doing these podcasts. Every episode is like you get to spend an hour with who's literally an expert in the field. So that's a real great experience for me. So thank you once again for your time, and I hope to do this again sometime.
And thank you for doing this. This is very interesting. I can learn from the other experts as I watch your episodes. This is a great thing to do for us too. So,
thank you so much. All right, thank you everyone. So that was Dr. Brown. We'll be back again in the next episode with a new expert witness. Till then, have a good one. Bye-bye. If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.